Hey, it's Candice Quinn with Contract Hack. Today we're going to talk about indemnification and what it means. It's the clause that everyone just glosses over until someone gets sued. Then everyone's all focused on it. But I'm here to tell you, if you can't explain indemnification in plain English to your client, then you are doing it wrong. Let's fix that. Here are 5 things that you absolutely need to know about indemnification. Number 1. What indemnification is. You absolutely need to be able to describe indemnification to your client in plain English. This is how I like to explain it. Indemnification is just a promise. One party agrees to cover the other party's losses if something goes wrong. Think of it like insurance. If I screw up and you get sued, I'll pay for all of your costs and expenses for the lawsuit and the damages that you have to pay. That's it. It's just risk shifting. It's just deciding upfront who's going to pay for what and under what circumstances. Number 2, there are 3 types of indemnification. There's first party, third party, and mutual. First party indemnification is pretty straightforward. If I do something wrong and I breach the contract, well, I'm going to pay for that. Third party indemnification is the one that we are typically negotiating in contracts. Think of it like this. If a third party sues you because of something I did, I will pay for the lawsuit expenses and the damages. For example, if you're a vendor and your product injures someone, your client gets sued for that injury, well, you're going to pay for your client's expenses and the damages from the injury. Mutual indemnification is just when each party has indemnification obligations towards the other party, typically third party indemnification. Now, mutual indemnification sounds fair, but it really is a risk shifting proposition, and you need to make sure that the risk is shifted properly based on the value and the risks taken by each party. Mutual is not balanced if one party has much more exposure than the other party. Number 3 is the scope of indemnification. How broad should the indemnification be? Well, it's all very dependent on the actual situation. And honestly, this is where most of the negotiations for indemnification come into play. This is where you determine what is actually covered by the indemnification. Is it everything from soup to nuts? Or is it just simple violation of law or IP infringement? What is covered by the indemnification? And even within a specific category, say infringement rates, is it everything arising out of an infringement claim? Or is it just things that are finally awarded in an infringement claim? The devil is in the details here. Small changes to words can really make a big difference in what is covered or not covered under the indemnification clause. Here's a hack. If you're the one giving the indemnification, keep it as narrow as possible. That keeps your exposure as low as possible. But if you're the one getting the indemnification, you want it as broad as possible. It's pretty simple, right? You want to give away as little as you can and you want to get as much as you can. And you always have to define what's excluded from the indemnification. You never want to be on the hook for the other party's gross negligence or intentional misconduct or willful misconduct at all. Number 4, the cap conversation. So sometimes indemnification is unlimited, but sometimes you need to negotiate a limitation of liability or cap for the indemnification.
Okay. I was saying that it's just not true. It's capped, to be honest. But
in some industries, unlimited indemnification is the rule, such as IP infringement in technology contracts. But in other industries, unlimited indemnification is very rare. So you need to know your industry and what's actually at stake in the issue you're negotiating. If you are negotiating a cap, that means you're putting a dollar limit on the indemnification obligation. So you will only pay up to X amount of money if you are on the hook to indemnify. But there's also some other ways you can be creative, such as baskets and deductibles. A basket means the indemnifying party doesn't pay anything until a certain dollar threshold amount is reached. So for example, they may not pay anything unless the expenses exceed $100,000. A deductible means that they will pay anything over a certain amount. So the indemnified party would be on the hook for $100,000 and the indemnifying party would pay for everything over $100,000. You also want to negotiate how long the indemnification lasts. Is it forever in perpetuity, or is it limited to the term of the contract? What exactly is reasonable in the situation that you're in? And number 5 is the insurance backup to indemnification. An indemnification doesn't mean anything at all if the party indemnifying you doesn't have any money to pay for damages. So in the case of a data breach, for example, if a company experiences a data breach and all of their clients are affected, they're probably going to go bankrupt and not be able to pay the data breach damages that their clients experience experienced. If all of their clients are getting a data breach indemnification at a very high amount, it's highly likely they won't be able to pay all of the damages. But if you tie the indemnification to their insurance limit and you're an additional insured on their policy, then you will be guaranteed to get that payout. So you want to make sure that the insurance language in the contract provides adequate coverage for the most likely risks to occur in the contract. Ideally, you'd want the insurance limits to match the indemnification obligations. You also want to see proof of insurance by getting the certificates up front and being named as an additional insured. If the other side can't or won't get insurance coverage, that's a red flag. You either need to renegotiate the indemnification, walk away, or accept the risk as a business. So there you have it. 5 indemnification essentials that every attorney should know in order to negotiate an indemnification clause for their client properly. Know what it means, know the types, know the industry standard for indemnification. Cap your exposure and back it up with insurance. If you master these, you'll stop getting steamrolled in negotiations, and you'll actually be able to explain to your client what they're signing and agreeing to. Are you looking for more quick hits on topics like indemnification and other commonly negotiated legal areas and contracts? Hit subscribe to my channel and I'll keep sharing my knowledge with you. If you think you're ready for some personalized one-on-one coaching, go ahead and schedule a free call with me. The link is in the QR code and the pinned comment and description below. Let's chat about how I can help you with your career and help you level up and reach your goals. Till the next time, hackers, bye!